As a protest of the Vietnam War, students, namely Christopher Eckhart and Mary Beth Tinker, planned to wear black armbands to school. The Des Moines Independent Community School District responded by creating a policy that would suspend any student who participated. Tinker and a few other students refused to comply with the policy in an act described by the 1969 Fordham Law Review article as a symbolic move that did not require what they described as long hair, short skirt, or a disruptive change in student behavior. Despite this, they were suspended, and in response, the students' complaint argued that this was a violation of their First Amendment rights of political expression, with a case decided by the Supreme Court on February 25, 1969. In the Supreme Court dissent, Justice Black argued that students are sent to school to learn, not to teach. He claimed that the demonstration was a distraction and worried that the court's interference undermines the school authority and might lead to further issues. Ultimately, however, in a 7-2 decision, the court ruled in favor of the students. Justice Fortas gave the majority opinion and stated that their act was pure speech and that this entitled them to comprehensive protection. Additionally, the school had not in the past prohibited students from wearing other symbols or political pins, and only this protest was singled out. Fortas argued that the school does not hold absolute authority over their students and that they can't just pick and choose what causes to allow their students to support. He stated that it was not true freedom of expression if there are restrictions on when and where students are free to express, as long as one student's freedom of speech does not infringe on another's. You'll see on the slide that standout quote about the schoolhouse gate that is still used when discussing this case and other censorship cases. And in that 1969 article, the case is described as a pathfinder in children themselves claiming the common rights of citizenship within their school environment. After attending a conference sponsored by the parents of New York United, the Board of Education of Island Trees ordered the removal of books that it had deemed anti-American, anti-Christian, anti-Semitic, and just plain filthy from the high school and junior high school's library. Despite receiving a different recommendation from their appointed book review committee of 4 parents and 4 school staff members, 9 books were removed. The issue was then brought to court by the students with the claim that this decision infringed upon their First Amendment rights, and the decision was reached by the Supreme Court on June 25, 1982. Elaine Price, in a 1983 Pace Law Review article, noted that even at the time of this decision, controversy over book selection was common. Chief Justice Berger stated that if the power of students and parents to overturn book selection by the school board became law, that the court would hover dangerously close to becoming a super censor of school board library decisions, and he believed that school boards should have this responsibility. He thought that the Tinker case only protected the freedom of speech and expression and not the right of access to particular ideas. But in a 5-4 decision, the court held that the First Amendment does impose limitations on a school board's discretion in removing library books. In Justice Brennan's majority decision, he referred back to the Tinker quote on the previous slide and harped on the unique environment of a school library, which makes it, in his words, an appropriate arena to recognize these rights, and that a lot of the discretion in making content decisions lies in the motivation behind of the removal, and that you can't just willy-nilly remove books just because you don't like what they say. Elaine Price noted the historical reluctance of courts to intervene in education areas like this one, but in this case recognized that it was their obligation because constitutional rights were in danger. Former students and newspaper staff of the Spectrum argued First Amendment rights were violated when the principal removed 2 pages discussing student experience with pregnancy and divorce. The Supreme Court decision was January 13, 1988. Justice Brennan argued that the newspaper was not just a class exercise but a form protected by the rights of free student press. However, in the final 5-3 ruling, the majority held that the school principal was entitled to remove the articles. Justice Byron White stated that the newspaper was distributed by the school and part of the curriculum, and that schools were not required to tolerate speech that is contrary to the academic mission. Additionally, the principal believed that there was not time for changes where student sources were identifiable. Forehand wrote in the Florida State University Law Review relating this to the Tinker decision, which instead dealt with political expression and not school curriculum, and included protection for the rights of other students. He also noted in Pico the library is a unique entity. In this case, the newspaper was part of the school curriculum, and so under the authority of the school, meaning the students' First Amendment rights were not violated.